The most misunderstood defenses that our clients often ask us about is entrapment. The idea behind entrapment is that if the police officers or the law enforcement set up a defendant and basically entrap them into committing a crime, that could be an affirmative defense. It's key to understand what are the requirements of entrapment. It's actually not so easy to use as an effective defense strategy in a criminal case, but if you know what to look for, it can be in certain circumstances. We just had a trial recently where my client was texted by undercover detectives. Now, my client got a text to his phone. Somebody was asking him to sell drugs. He responded to that text message. Again, it turned out to be a detective on the other side of that phone. He responded to the scene, was about to make a sale to the detectives, until at that point he was arrested. Now, this case can possibly qualify for entrapment, but it completely depends on the history of the individual. In order to qualify for the entrapment defense, a defendant must not have been predisposed to that particular crime. So, if a client never has sold drugs before, doesn't even have access to drugs, and all of a sudden is texted by a detective, hey, I want you to get me drugs. And that person responds, I don't have any drugs. And the detective then says, come on, please, please, I need something, and tries to convince that person to do something he wasn't otherwise predisposed to do. That can be an affirmative defense of entrapment. Now, it's important to realize what an affirmative defense is. That means that unlike your criminal case, where the government has the burden of proof to prove the defendant guilty, in order to establish an affirmative defense like entrapment, the burden is on the defendant to prove that he was entrapped by the police. The fact that in the drug user's phone, detectives found text messages between my client and this other individual about prior drug sales showed the judge that my client may have been predisposed to drug sales already, and therefore he did not qualify for the entrapment defense. Now, again, it's critical to be able to evaluate each and every case where the police are the ones who are initiating contact. And like I said, the critical point is the individual predisposed to committing that crime or not? And if the person's not predisposed to committing the crime and is just convinced to do it by law enforcement without any history of committing that particular crime, is the quintessential case of a good affirmative defense of entrapment. Another type of case regarding where entrapment would not apply is, let's say, an undercover detective going for an illegal massage. The person conducting the massage, or the person calling for a sex worker to come and provide services to them. The defendant, I was entrapped. The law enforcement came to me for the illegal massage, or the law enforcement contacted me to come provide some type of sexual service. Yet because that defendant, in all likelihood, was predisposed to that crime, that's someone who's already providing perhaps illegal massages, or perhaps already a sex worker, that person won't qualify for the entrapment defense because they are already predisposed to that crime.